We're back on the air. This is Radio Entrepreneurs, and if you haven't noticed, we're being hosted all week long at O'Brien and Levine Court Reporting Solutions. That means the show is on the record because we're only interviewing attorneys all week long, and that means I have Mark Z from Mark Z Legal Staffing as my partner and backup.
A partner, backup partner in crime. It's always a pleasure, Jeff.
It's great when we have these specialty lawyers on because you just drive into their categories because you're an attorney too, aren't you?
I am, and it's fun because to get some insight and comments on key issues.
It's like going to school, isn't it?
It is. I always learn something and a lot of great nuggets.
Yeah, I learned that you have to treat the law with respect.
Correct.
That's one thing you learn when you speak to all these attorneys.
Correct.
And our next attorney, I know someone you were pretty excited to meet. You were waiting all day. You kept saying, when's Ken Parker coming in? When's Ken Parker coming in? And now finally we have Ken Parker coming in from Parker Keough. So welcome, Ken.
Welcome, Ken.
Thanks for having me.
Ken, according to Mark, you have a very interesting practice. And you've gotten yourself into a lot of different things that you're involved with. And why don't you tell us about it?
Well, we're primarily a business law firm, so our major area of our work is representing small, medium, and growing, and some larger 100 million plus revenue companies in primarily the areas of intellectual property and transactional work and dispute resolution, which includes litigation. It's always our goal to keep our clients out of court. So one of the things we do is we try to draft very clear contracts where there's no ambiguity and the parties know exactly what they're supposed to do. We find that most of the disputes that arise that end up in court that are contract breaches aren't because someone willfully breached a contract. It's because there was a dispute as to what the obligations were under the contract. And so our goal is to do what the new school of thought in contract drafting is called plain language drafting, so that you don't have to be a lawyer to understand what the contract says.
That's
Anybody
great.
who's reasonably educated and proficient in the English language can go, oh, this is what I'm supposed to do. Here's when I'm supposed to do it. Here's what happens if I don't do it. And here's what the other side is supposed to do, and so on and so forth. And I find that if you write clear contracts, usually you can work out any dispute. Someone doesn't want to do something, well, it's crystal clear they're supposed to do it.
Right.
And that way you don't have those problems. There are other problems, of course, in the intellectual property area. If you don't identify, for example, if you've got a contractor working on something, well, who's going to own the IP in the end work product? So that gets into the contractual relationship, but also a lot of is there an assignment clause in the contract? Is it a work for hire? So a lot of what ends up happening is if you can have clarity of obligation early on and identify putting in the proper intellectual property protections, down the road you avoid conflict.
Right. What's special about your firm, which in a lot of cases firms are a litigation firm or a firm of business law, what you do is you can get involved with the client from incubation to growth and all the issues. So, for example, as they're born and I started, you could tell them how to do the right documents, how to have
As
preventative
complexity
measures.
changes, documents need to change.
Right.
Well, you're absolutely right that an ounce of prevention really is worth at least a pound of cure, maybe 3
Right.
or 4 pounds of cure
Right.
in this case. But the reason for that, of course, is if you set up an entity, like some people, we've had entrepreneurs say, hey, I just want the product to work, man. I can't worry about this. These are brilliant young people. They're in graduate school. They're working on PhDs, perhaps, and they've got these really exciting ideas. I mean, we get to work with some of the smartest. What makes my job so much fun is I get to work with such smart, such creative people.
It's good to be in the Boston area.
Yeah, well, but also dealing with intellectual property. What does that mean? You're dealing with scientists and inventors and artists and writers and
Right.
creative people, musicians.
Right.
One of our clients, right after a client meeting, went to play Carnegie Hall.
Wow.
So it's you get to deal with some really terrific people. And I find that if, so we at first, sometimes they'll walk in the door and say, look, I don't want a lot of this paperwork stuff, these documents, as you say, because all I want is my product to work. And I said, well, that's very noble of you to give your product to the world. You're going to design this and it's going to be free for everyone to use. Is that what you want? No. I want to be able to own it and license it. Well, then you probably want some patent protection, perhaps if it's an invention, or to register a copyright, or if you don't want people using your brand name. You might want to trademark, or perhaps you've got a client list or some other information that you want to keep to yourself and you make it a trade secret. Well, most of the people who walk in our door who are in a conflict, it's because they didn't take these reasonable precautions. So a former employee, for example, will go off and start a competitor using their customer list, maybe using their proprietary methods, their trade secrets. And a lot of this, obviously, there are bad people in the world who will do bad things, but if you want to protect yourself against those things, it really makes a lot of sense to have clear agreements and procedures that are consistent with those agreements. For example, you don't get trade secret protection unless you actually, wait for it, keep the information secret,
Right.
or endeavor to do so.